I'm still holding brief.
I had a ruling to read.
Yes.
Okay.
I'll take it.
I considered the rival arguments between Mr. Nyariki and Ms. Bundi over the subject of withdrawal of suit as against the second and third defendants. It is tried that the suit belongs to the parties and that in the event that a party wishes to withdraw his suit against some or all of the defendants, the court cannot stand in the way of such a party, and that the only recourse available to the opposite party is in respect to costs that he or she may have incurred in the matter. For these reasons, I hereby allow the plaintiff's application to withdraw the suit against the second and third respondents, defendants, with costs to the said respondents.
I indicated already that Mr. Nyamangi had filed response to submissions.
Yes.
Then we, on our part, we take the ruling late.
Ms. Bundi is not there.
I will see.
I can see applicant submissions. I can see first respondents' written submissions. Mr. Nyariki, are you on the call?
Yes, I'm present, Your Ladyship.
Yes, the application to withdraw the suit as against the second and third defendants has been allowed. So with the cost to those defendants, I'll proceed to give a date for ruling in respect to the application.
Now, the matter has been withdrawn, but you will give a ruling considering our submissions.
There is the first defendant submissions.
Yeah.
There is the applicant submissions. Did the fourth defendant make any appearance?
No.
I will deliver a ruling based on the parties that are remaining in the matter.
So we shall be at the liberty to do what is appropriate concerning the value.
Sorry?
Yeah, so since now that they have withdrawn the case against us, we are not bound by the injunction that was granted.
You know the order that was granted, counsel?
Pardon?
What were the orders granted?
The orders, as I can see them on the face of the application.
Yes.
Was that there be, just read it.
What were the orders?
That the first, second, and third defendants, respondents are hearing or their actions or any producing under their instructions are restrained from barring the body of Prasio Ori or barring Prasio around Ori on land parts of that subdivided to make 4531 and 45 pending the hearing and determination of this application.
Yes.
So, for clarification purposes, now that the matter has been withdrawn against the second and third, they are at liberty to do what they want to do because they are not bound by that order now.
That is your interpretation?
Yeah, that's my interpretation because if the matter has been withdrawn, then the orders cannot bind him.
Counsel, the court order speaks for itself.
Yeah, but I'm saying that's why I seek clarification from the court. Now that they have withdrawn the suit against the second and third, and they bound by that order of injunction.
That is not for me to interpret for you, counsel. The order was to be there until the matter is heard and determined. I don't think the whole suit has not been withdrawn. It is only as against the second and third defendants.
Yeah, but the orders cannot.
I think
give me a date for ruling. Give me a date for ruling, Anita.
My lady, we have 2nd of May.
2nd of May. Miss Bundi, the court is in session. I'll call you when I need to hear from you. Give me an early ruling. Right. This is a burial dispute.
18th of April, my lady.
That is the earliest.
Next week.
Ruling will be delivered on 18th of April.
18th, my lady. 18th.
18th.
Yes.
18th of April for ruling.
And that's a ruling between the friend, the applicant, and the third defendant. We are not part of that.
Call the next matter.
What if we get a consent before it is?
Just for good measure, interim orders extended until then.
All right.
Next, we have High Court Constitution Petition, case number 001 of 2024, Jared Mairura Ratemo versus the Senate.
So this is the order of the court. This matter was placed before me for mention today, having been transferred pursuant to orders by Justice Ogola made on 4th April 2024. At the mentioned parties sought directions on how to proceed with the matter, especially on the issue of representation in the matters that were originated from Machakos High Court, in light of the notice of change filed by the petitioner, alongside a notice of withdrawal of petition. Mr. Muli, learned counsel for petitioner, submitted on the issue of representation between himself and Ms. Kariuki. He stated that the issue be determined first. On her part, Ms. Kariuki maintained that the change of advocates would not take effect until she is served with the notice of change. Ms. Kariuki further stated that her client, the petitioner, had disappeared and that she had been unable to reach him. In a rejoinder, Mr. Muli informed the court that the petitioner was on his way to court and that there would have been a police report if indeed the party had disappeared. This court notes that the petitioner later appeared in court today in person, and he confirmed that he had indeed changed advocates on 28 March 2024. I have perused the proceedings of 4th April 2024. That is the proceedings before Justice Ogola, and I note that the issue of notice of change of advocates arose before the said judge, when the issue of withdrawal of petition also arose. I note that Ms. Kariuki was in court on the said date. I therefore find that she must have had notice of the change of advocates. Having noted that the petitioner appeared before me in person and confirmed that she had indeed changed advocates, this court finds that the change of advocates took effect the moment the same was filed in court. In sum, I find that Mr. Muli, advocate, is properly on record for the petitioner, which means that Ms. Kariuki is henceforth excused from these proceedings. Those are the orders of the court.